Good evening and welcome to Courts Today by LiveLaw. I am Urvashi Chauhan and in this video we cover major court updates from across the country. Justice Yashwant Varma's plea against the CJI's recommendation gets dismissed by the Supreme Court, and the UP police faces tough questions in the Lakhimpur Kheri case. Plus, courts weigh in on serious POCSO convictions, bail for Asaram Bapu, and the need to revisit citizenship laws. All that and much more. Watch till the end and make sure to like, subscribe, and don't forget to hit the bell icon. In a major development, the Apex Court today dismissed the writ petition filed by Allahabad High Court Judge Justice Yashwant Varma. The petition, as you know, had challenged the report of an in-house inquiry that indicted him in connection with a massive cash recovery at his former Delhi residence, as well as the recommendation made by the then Chief Justice of India, Sanjeev Khanna, for initiating his removal. A bench of Justices Dipankar Datta and A.G. Masi had reserved its verdict on this on 30th July. Pronouncing the judgment today, the bench said that the writ petition itself was not maintainable, given that Justice Varma had participated in the in-house inquiry and could not now question the panel's competence. However, despite holding the petition as non-maintainable, the bench addressed the 5 constitutional questions raised in the matter due to their significance. On the issue whether the in-house inquiry had any legal sanction, the court held that procedure does have legal backing and it does not amount to a parallel or extra constitutional mechanism. The judges also addressed the validity of paragraph 5B of the in-house procedure, which allows the CJI to forward the report of an in-house inquiry committee to the President and the Prime Minister, which may have found misconduct or impropriety on the part of the High Court judge. The bench has held on this aspect that it does not violate Articles 124, 217 or 218 of the Constitution. On the question of whether the Chief Justice of India and the Inquiry Committee acted as per procedure, the court held that they did so scripturously, just with a minor exception: the uploading of the video and photo evidence of the firefighting incident on the Supreme Court website. But even this lapse, the bench said, did not materially affect the matter, as the petitioner had not challenged it at the right time, nor sought any relief on this account. As of whether forwarding of the report to the President or the Prime Minister without giving Justice Varma an opportunity to be heard was unconstitutional, the court said that no such requirement exists in the procedure, and a past instance of a judge being heard could not be treated as a binding precedent. Importantly, the bench clarified that Justice Varma retains the right to raise his defense in any impeachment proceedings that may be initiated. The court also dismissed a separate petition filed by Advocate Matthews J. Nedumpara, who had sought registration of an FIR against Justice Varma, alleging abuse of the judicial process. Let me tell you here, appearing for Justice Varma, senior advocates Kapil Sibal and Mukul Rohtagi had argued that under Article 124(4) of the Constitution, a judge can only be removed for proved misbehavior or incapacity. They said that the in-house procedure cannot form the legal basis for removal, and a CJI's recommendation does not fulfill the constitutional threshold to initiate impeachment. However, Justice Datta had earlier remarked that the in-house procedure is only a preliminary internal inquiry, not a full-fledged trial, and its report is not treated as legal evidence. Therefore, the petitioner could not claim to be aggrieved at this stage. Next, an update in the Lakhimpur Kheri violence case. The Supreme Court today directed the Uttar Pradesh police to verify allegations of threats and inducement made by a witness in the case involving Ashish Mishra, son of former Union Minister Ajay Kumar Mishra. The direction came in light of a complaint by one Baljinder Singh, who alleged that he was offered a bribe and threatened with dire consequences if he deposed in the case. Despite the complaint, no FIR had been registered by the UP police. Let me help you recall, this case stems from the October 2021 incident where vehicles from Ashish Mishra's convoy allegedly ran over protesting farmers, leading to the death of 5 people. The Supreme Court had taken suo motu cognizance and criticized the state police for delays in arresting Mishra. Mishra was granted interim bail by the top court in January 2023, which was extended and eventually made absolute. In May last year, the court relaxed some bail conditions, permitting Mishra to visit Lakhimpur Kheri once a week to meet his family, with a clear restriction against participating in political or public meetings. A bench comprising Justices Suryakant, Ujjal Bhuya and N. Koteshwar Singh of the Supreme Court today expressed dissatisfaction with the explanation offered by state for not registering FIR on the complaint made by Baljinder Singh. Advocate Prashant Kumar, appearing for the victims, informed the court that liberty had earlier been granted to Baljinder Singh on 24th March to file a complaint regarding threats. He stated that Singh submitted a written complaint on 20th June alleging that he was offered 1 lakh rupees to remain silent and threatened if he deposed. Yet, despite the clear mandate in the Lalita Kumari judgment requiring FIR registration within a week for cognizable offences, the police took no action. Appearing on behalf of the state, Additional Advocate General Garima Prasad submitted that the police had called Singh for an inquiry, but he did not appear. However, the court observed that this was not a satisfactory excuse and stressed that if a complainant was reluctant to come forward, a senior police officer ought to have verified the complaint in person. The bench has now ordered the Senior Superintendent of Police Lucknow to verify the complaint and file an affidavit. Bhushan pressed further, arguing that if the allegations in the complaint are verified, it would amount to a breach of bail conditions and Mishra's bail should be cancelled. This was strongly opposed by Senior Advocate Siddharth Dave, appearing for Mishra, who asserted that there was no proof linking the threats to his client. Dave also informed the court that 20 witnesses had already been examined and 20 had been dropped, adding that although the trial court was hearing the matter thrice every month, many witnesses failed to turn up. While Bhushan requested the court to direct day-to-day trial hearings, the bench declined, reasoning that such an order could impact scheduling in other cases. The court also directed the trial court to examine as many witnesses as possible on the next hearing date. Moving ahead, the Supreme Court has delivered a powerful and uncompromising judgment in a case involving incestuous sexual violence, upholding the life sentence of a man who repeatedly raped his 10-year-old daughter. Calling it a case of unspeakable betrayal of trust, the bench of Justices Arvind Kumar and Sandeep Mehta rejected the convict's plea for leniency, observing that incestuous offences must invite the severest condemnation and deterrent punishment. The father had claimed that he was falsely implicated due to family disputes, but the court dismissed this and said that no daughter would fabricate such grave allegations merely to escape domestic discipline. Reinforcing the fundamental values of family trust, the court stated that a home must be a sanctuary and not a site of repeated trauma. In a landmark move towards restorative justice, the court also directed Himachal Pradesh Legal Services Authority to pay 10.5 lakhs as compensation to the survivor, who is now an adult. This compensation is to be paid under the 2018 scheme for women victims and survivors of sexual assault, framed pursuant to the Supreme Court's earlier judgment in Nipun Saxena versus Union of India. The court concluded that justice must not stop at conviction. It must include restitution. It reaffirmed the judiciary's duty to ensure that justice is not only legal but also compassionate, complete, and survivor-centric. The Rajasthan High Court has delivered an important judgment touching on the rights of children born to Indian citizens outside India. In a case involving a 5-year-old girl born in Australia to Indian parents, the court has urged the Union Ministry of Home Affairs to reconsider and, if necessary, amend citizenship-related laws to address the growing challenges faced by such children. After her birth, let me tell you, the child was brought to India by her parents and has been residing here since. However, things took a complicated turn when a matrimonial dispute arose between the parents and multiple criminal cases were filed by the mother against the father. Because of their strained relations, when the father tried to get the child's visa extended, the mother did not give the required no objection certificate. As a result, the visa application was rejected and the child was suddenly left in a legal limbo without valid documents and at the risk of being treated as an illegal migrant and be deported. The petition was moved before the Rajasthan High Court seeking relief, especially extension of the visa and issuance of an OCI card for the child. Justice Anup Kumar Dhand, who heard the matter, observed that the child could not be left at the mercy of her parents' strained relationship. The court said that in such peculiar cases where both parents are Indian citizens and residing in India, the legal system must prioritize the best interest and welfare of the child. The court has directed the Foreigners Regional Registration Office to extend the girl's visa for the maximum permissible period without insisting on the mother's NOC. The court also instructed that her application for an OCI card be considered sympathetically within 3 months. But the ruling went far beyond individual relief. The High Court took the opportunity to highlight a critical legal vacuum affecting countless children like her. It held that the law, both domestic and international, must evolve to secure the best interest and welfare of children. Referencing the UN Convention on Rights of Child, the court reiterated that best interest of the child must be the paramount consideration for all nations. It also cited Article 21 of the Constitution, that is the right to life and personal liberty, noting that while foreigners don't enjoy the right to settle in India, they do enjoy protection under Article 21. In this case, where both parents are Indian citizens residing in India, forcing the child to leave the country would violate that fundamental right. Further, it also urged the Government of India to revisit the legal framework governing citizenship, visas and residency for children born abroad to Indian parents, and if required, bring in suitable amendments that ensure children's welfare remains central. The Gujarat High Court today extended temporary bail of Asaram Bapu, who is currently serving a life sentence for rape till 21st August, keeping in mind recent health complications reported by him. Asaram, who was convicted in 2013 for the rape of a minor by a sessions court in Gandhinagar, had earlier been granted temporary bail by the High Court. On 3rd July, his bail was extended for 1 month, but this extension came with a firm note from the court. His counsel had then assured that no further extensions would be sought, and the court had clearly recorded that any fresh plea for further extension on medical grounds would not be entertained. However, despite this earlier assurance, Asaram has now approached the High Court again, seeking another extension of his bail. This plea was moved within his pending criminal appeal challenging the conviction itself. During the hearing, the division bench of Justice Ilesh J. Vohra and Justice P. M. Rawal inquired about the Supreme Court's order dated 30th July on the matter. That order came in response to Asaram Bapu's plea against the High Court's 3rd July order. The Supreme Court had refused to interfere with the High Court's decision but had left a small window open. It allowed Asaram to approach the High Court again if his health condition deteriorated after 3rd July. Following this, the Gujarat High Court asked the state government's counsel for an update on Asaram's medical condition and documentary evidence. The state submitted that the applicant appears to have suffered a cardiac-related issue in July and assured the court that the condition would be verified through reports from both hospitals where he was treated. When the state suggested that his bail be extended till 14th August only, the bench said otherwise. Justice Vohra stated that the court would instead extend the bail until 21st August, giving sufficient time for medical verification and further developments. So the matter is now listed for 21st August, when the court will once again take stock of Asaram's medical status and decide the future course of action on his bail. In the alleged rape of a 7-year-old girl by a 16-year-old boy, the Himachal Pradesh High Court has held that preliminary assessment conducted by the medical board in accordance with Section 15 of the Juvenile Justice Care and Protection of Children Act found that the accused had an IQ of 92 and was fully aware of the consequences of his acts, as he had threatened the victim and told her not to disclose the incident to anyone. Justice Rakesh Kentla remarked that the boy did not suffer from any mental or physical incapacity to commit the crime, and the Juvenile Justice Board was right in referring the matter to the Children's Court to try him as an adult. As submitted by the police, the petitioner's age was found to be 16 years, 1 month and 23 days at the time of the incident. Thereafter, the Juvenile Justice Board carried out a preliminary assessment and referred the case to the Children's Court to try him as an adult. Aggrieved by this, the boy filed an appeal before the Sessions Judge Shimla, which was dismissed. Thereafter, he filed the petition before the High Court, asserting that the preliminary assessment was not conducted within 3 months as required under Section 14(3) of the Juvenile Justice Act, and further, the documents of the case were also not supplied to the medical board. But the High Court has now dismissed his revision also, saying that the Apex Court has previously held that period of completion of preliminary assessment under Section 14(3) is not mandatory but directory. In a significant ruling, the Karnataka High Court has struck down Rule 6 of Karnataka State Human Rights Courts Rules 2006, calling it unconstitutional and inconsistent with the Protection of Human Rights Act 1993. This Rule 6 allowed victims of human rights violations or even their legal representatives, registered NGOs or public-spirited individuals to directly approach the Human Rights Council, which is essentially a sessions court designated by the state government, to file a private complaint against a public servant. Once such complaint was filed, the court could order an investigation or conduct its own inquiry, treating it just like any other private complaint under CRPC. Well, Justice S. Rachaya has made it clear that the rule went beyond the scope of the Parent Act, that is the Protection of Human Rights Act. which is a central legislation. Under this act, only the Human Rights Commission, whether at the national or state level, has the authority to conduct inquiries into complaints of human rights violations. The process laid down in the act is quite clear. The Commission first conducts a preliminary inquiry. If it finds evidence of violation, it may recommend action to the concerned government or authority. Only then can any prosecution be initiated, and that too based on the Commission's recommendation. According to the court, this Rule 6 bypassed this entire process. It allowed a victim to walk into a human rights court directly, skipping the Commission altogether. This, the court said, disrupted the legislative intent and invaded the domain of the Central Act. The court also noted an important legal principle of double jeopardy. If a person is already being investigated or prosecuted based on a commission's recommendation, allowing a parallel private complaint before the Human Rights Commission could lead to the same issue being prosecuted twice. Moreover, human rights is not like other laws such as Prevention of Corruption Act or the SC/ST Act, where standalone offences are defined and direct prosecution is possible. The Human Rights Act is structured around inquiry and recommendation, not direct criminal trials. Citing Section 41 of the Act, which allows the state government to make rules but only in respect of administrative aspects like salaries and conditions of service, the court held that Rule 6 went far beyond what the law permitted. Therefore, the FIR in the present case, filed on the basis of a private complaint alleging police abuse, was quashed. The court has, however, clarified that this ruling will operate prospectively, meaning it will not affect past proceedings initiated under Rule 6, but will apply going forward.